everyone. My name is Dorothy Deng. I am a partner at Whiteford Taylor Preston's nonprofit association and political organization practice group. So today we're going to have a presentation about privacy compliance and talk about personal data processing. This is going to be a one-on-one session, but we will nevertheless give our audience practical tips and suggestions about how you can comply with privacy law in the US and consider how do you aspire to follow the best privacy principles going forward. So I have two colleagues with me today from our data privacy security practice section, Roz and Kristen, and I will have them introduce themselves and before we get into the formal part of our presentation.
Hi, and Dorothy, thank you for having this get together. I'm a privacy and data security lawyer with Whiteford Taylor and Preston. Most of my practice, I deal with organizations that handle technology, and I focus on their privacy and data security needs. I prefer to take on projects that handle emerging technologies, new and cool pioneering stuff that's happening in the privacy and data security world. And luckily we have clients who handle lots of transatlantic operations, both going from the US to Europe and the rest of the world and the other way around.
So thank you, Roz. So Roz is very knowledgeable when it comes to a lot of global data transfer and things like that. And then we also have our other colleague, Kristen Bertch. So Kristen.
Thank you, Dorothy. So I work closely with both Roz and Dorothy on nonprofit clients, as well as helping Roz with emerging technologies. I work quite a bit with companies that have experienced data breaches, companies that are concerned in working on updating their privacy policies and procedures, or some contract review to make sure that the appropriate safeguards are in place, as well as a focus on some existing privacy laws such as HIPAA, and some newer privacy laws that have been passed, and we'll discuss some of those later in the presentation.
So thank you very much. And I think we'll have a very good overview. And as I said earlier, this is a one-on-one session, so we hope you will enjoy it. So to frame our conversation today, I want to mention, and I'm sure if you're tuning in, you are interested in this topic. So in the recent years, the general public has been very much more aware about data privacy issues. So with the GDPR in the EU implemented and a lot of new US privacy legislation being introduced, what are some of the business trends that the two of you have been seeing? Again, briefly, just to warm up a little bit for our conversation. So Roz, why don't you go first?
Sure. So I would say if I had to pick three business trends, it would be, first, we are starting to see, and this is not in small part because of the GDPR, and both in the for-profit and nonprofit worlds here in the United States, a tendency to take privacy a bit more seriously, and for clients to ask questions about privacy and what are some of the considerations in designing our business model and so forth. The second thing is related to the first one. We see many of our clients kind of getting used to the cycle of every year things are becoming more and more complex on the privacy front. So they're trying to get ahead of the curve. So one of the things we're seeing our clients do is trying to go above and beyond what is currently required, and what is currently required by law. And then the third aspect that we're seeing is that clients are realizing that data is valuable, but it also generates quite a bit of potential liability, or could cause quite a bit of liability. And in particular, we're seeing that even at a basic level when we're negotiating contracts, that oftentimes the value of the risk with respect to privacy liability of a contract can be many times over greater than the value of the contract itself. So these are some of the risks that we're seeing.
So thank you, Roz. And I think that's a very good segment into this slide that we're currently looking at. So this slide, I did not author the content. It is directly copied from the GDPR in terms of the principles relating to processing of personal data. So if your organization is subject to the GDPR, and if you are a data controller, then you must demonstrate that your data processing abides to these privacy principles. If your organization is not directly subject to the GDPR, nevertheless, you are looking at a very good summary as to what are the best practice that you should aspire to. So I personally really like these principles. I think they're very easy to understand, at least just the language itself. That being said, I'd be very interested to know from Kristen and Roz about when we are looking at this slide of best privacy principles that is required by the GDPR, what is the number, what is one of the principles that a lot of businesses and organizations tend to overlook? And how can they do better to abide with the best practice or aspire to work toward compliance? So Kristen, why don't you share what you think?
So that's a great question, Dorothy. I think one of the principles that we really should be focusing on, I mean, they're all important, but one of the principles that I really like to focus on with companies is data minimization. And I mean, the reason for that is twofold. One, just as Roz was going over in the introduction, you're seeing a lot of companies, even when they don't have to comply, they're starting to try to use best practices. And when they're doing that, what they're doing is they're kind of doing an inventory of, you know, what do we have? How do we address it? And something that is so important is for you to consider what data you need and what data you don't need. Because again, back to what Roz was saying about the contracts, there's liability in data. I mean, it's an asset, but it can also be a liability, especially in cases where that data includes personal or, you know, overtly sensitive information. So if every organization looks to see what data they have and does an assessment of what data they need versus what data has just been around, it can drastically decrease the risk of business in the case of, you know, a data breach, or if they're a vendor, you know, possible liability to their clients. And it's one of those things that I think if every organization really focuses on and pays attention to, they can just overall decrease the risk that their organization is holding.
Thank you. So other than data minimization, Roz, what principle do you think a lot of businesses tend to overlook?
So again, we're trying to kind of take a basic approach to privacy, and let's assume that we are dealing with organizations that are kind of at the outset of adopting a privacy program. And I know you're asking for one, but let me suggest two, and for two separate reasons. One, probably the most difficult one, and difficult from a technical standpoint, and it can be difficult even for organizations with a more advanced privacy program, I would say, is the storage limitation. The idea that you should not overlook the data that you collect. You really need to pay attention to that data throughout the entire life cycle of that data. and where you ultimately store data for backup, for whatever reasons you're doing it, is a really important aspect to consider and requires due diligence with your vendors. It requires technical understanding of how data is actually stored. Is it de-identified? Is it encrypted? What kind of protections do your vendors have with respect to perhaps their subcontractors? That could be cloud service providers and so forth. So I would say from a difficulty standpoint, because it could impose some technical challenges for organizations that are just getting started, the storage aspect can be challenging, and it presents quite significant risks because those vendors could be subject to data breaches, for example. From a different standpoint, the lawfulness, fairness, and transparency principle, which seemingly is the easiest one to tackle and is often viewed as the low-hanging fruit, right? We all look at privacy policies, and the first thing an organization may want to do when thinking about privacy is, well, let's update the privacy policy. And I think this underestimation, underestimating the effort it takes to truly understand what data you're processing, how to be transparent about what you're doing with the data, meaning to have external policies that describe accurately what the organization is doing with the personal data on the back end, can be quite a challenge. It requires a little bit of data mapping. It requires a little bit of internal due diligence. It requires understanding on a holistic level, well, what are we doing with our data? You know, what data are we collecting for what purposes? Does IT know what marketing is doing? Or does finance know what marketing is doing? And so forth. So from that perspective, even though lawfulness, fairness, and transparency may seem like a low-hanging fruit, it does have quite the pitfalls to watch out for.
Thank you, Roz. And I think we are, with what Kristen and Roz shared, I want to give just my, compared to the two of them, that is the bulk of their practice, but I do touch on privacy issues for our nonprofit association clients quite a lot. And it came from a long time ago when I started to practice, and I would explain that the more old school US legal framework is exactly what Ross said, right? Be transparent. So say what you do what you say, give notice, and people have the opportunity to not participate. So that is the more old school or more tradition US foundation of many US statute, which is going to change, and we will discuss that later part in our presentation. But I think for one activity that almost all of our clients do, businesses and nonprofit organizations and associations alike, all of them do a lot of marketing activities, such as collecting data from your customers, from your members, from your donors, to do your internal market research. Most of the organizations do send out newsletters or marketing emails. Some organization would sell data share their customer list to exhibitors, sometimes to other third parties in exchange of revenue. So I would like to ask Kristen, what are some examples that you've seen that is the current law that regulates these marketing activities, and what are the key compliance requirements for regulating marketing?
So great question. And marketing, as you said, is very important to, a number of businesses. And one of the older laws actually that really comes into play that we still discuss quite a bit today is CAN-SPAM. And the overall idea behind this law is if you are sending out a marketing email, an unsolicited marketing email, you're required to allow the recipient to opt out. So actually, if you go through your inbox and you're looking at, all of these marketing emails that you get, if you scroll to the bottom, you're actually probably likely to see an opt-out button that says, hey, I don't want to receive this anymore. And the reason we get this is can spam. And that's, again, with the old school methods that you were talking about, the whole, hey, you're allowed to send these out, you're allowed to do this, but you have to give consumers the option to say, no, I don't really want to receive this. Some other aspects of can spam specifically is making sure that you're being transparent and honest. So you can't have, a deceptive title, and you have to make sure you say, who this comes from. And this actually also goes into another FTC enforced rule concerning deceptive practices and deceptive advertisements. And the just general idea behind this is if you are going to make representations to consumers, you want to make sure that you're straightforward and honest. And in the case of something like can spam, you also have to make sure you're following the rule of the law. As far as other laws that are currently passed right now, we have a newer law, the CCPA, which we'll be talking about a little bit later during this presentation. But that also has very specific laws when it comes to marketing and more specifically the sale of consumer data.
Thank you. And I think it's helpful to mention that in the United States, the FTC is the agency that enforces a lot of these privacy violation by big tech. Now you see some of the enforcement actions. And the basis, again, this is more of the traditional reason behind the enforcement, is to use consumer protection. So it's generally under the bucket of protecting consumers. So that is how, at least so far, but there's going to be more at the state level, etc. But historically, it is the FTC that has been the enforcement arm for this type of enforcement actions. So thank you, Kristen. And Roz, there may be other additional legislation, maybe not necessarily strictly for privacy, but related about personal data. So maybe can you share for marketing activity purposes, is there something that you would like to share?
Sure. So a couple of things that come up quite frequently, and again, they're hard to gloss over, but they can present significant risks. One aspect is organizations in the U.S. are now starting to take basically account of their offshore operations, some of their activities abroad, and those activities abroad may subject them to laws that, even though the organizations are based in the U.S., laws such as the EU General Data Protection Regulation, known as the GDPR, or maybe some Canadian laws could apply to their activities. And here the analysis can be quite factual and has some complexity to it. There are all sorts of things to consider, some legal concepts to consider, such as on what legal or lawful grounds are we allowed to market to individuals. So under the GDPR, for example, you would look at, well, can we directly market to our constituents, relying on our legitimate interests? When is consent required? So when do we switch to an opt-in kind of framework? Then the same is true for Canadian laws, where things could get even more complicated because Canadians are segregated in provinces, and all these provincial laws could come into play. Again, to add a complexity, this is not to say that Europeans themselves don't have a whole lot of national laws that apply to marketing operations, and therefore we need to work with local council for marketing campaigns. And there are some laws that are currently being negotiated at an EU level. So if marketing relies heavily on sending emails Then the issue of the privacy regulation and when that law will govern and be a unified law in the European Union still remains to be a question. The excuse me. The other aspect is beyond simply the purely privacy aspects of privacy laws. A lot of these privacy laws reference data security safeguards that organizations need to put into place when processing personal data. And that kind of imports a whole lot of concepts. And in particular, here's where organizations are learning to fully appreciate the difference between what is privacy, what is data security. And that's where we get into, well, what is in the domain of privacy and what is in the domain of data security. And to greatly summarize, typically the conversation goes in the direction of, well, privacy is a right that an individual has as to his or her rights. And that could mean any number of things depending on local legislation here in the US or EU or Canadian or Asian countries' laws. And then, and by the way, each of these countries gives different kind of deference to these privacy rights. So in the US, for example, there's no true constitutional right to privacy, except maybe with respect to the Fourth Amendment, with respect to government action. But in the EU, for example, privacy is a fundamental right, so it is elevated. And then on the data security side, the question is, okay, well, what is data security and how is it different from privacy? And there are two distinctive aspects. One is data security refers to protecting data that goes beyond kind of personal information, personal data. You also protect trade secrets. You protect confidential information that may be subject to an NDA, for example. And then the other aspect is data security refers to safeguards. And typically these are siloed into physical, administrative, and technical safeguards. So then you need to address that aspect that may be imported into these privacy laws.
Thank you, Roz. So I want to at least try to summarize one of the two things that I find to be particularly interesting. One thing is kind of tying into this 101 theme and tying with what Kristen used an example of canned spam versus the Canadian model, because that is one of the, for me, one of the more common question I receive is relating to that compliant component, which is consent. So as Kristen mentioned earlier, in the US, I like how the statute is called. It's called you can spam, right? Can spam. You can spam as long as you let people unsubscribe. So that's the opt out because you let people unsubscribe. But as Roz mentioned, one of the fundamental, and in reality, that's a practical distinction for businesses, is if you are subject to Canadian law, and likely many of our clients have some operation and customers, members in Canada, they use an opt-in model. That is, you cannot spam unless you have consent ahead of time, even though consent can be implied or expressed. But the standard is much higher. It's a reverse. So that is one thing that businesses should keep in mind. Again, we're keeping at this at a 101 level, but I do think that's worth pointing out. The second one is also a segment into our next question for my colleagues is there are many legislation in the works in the United States, and there is a distinction between privacy and data security. The two of them do come hand in hand in the statute, at least the ones that's being introduced, but there's historic reasons for that, and Roz mentioned that in his what he just shared with the audience. So I think that would lead to our next question I would like to ask. I know Kristen has been watching a lot of the development as to some of the legislation that's being developed, and also the new, very new privacy law in California. So Kristen, would you like to share some of, again, the trends in the United States, tying with the principles that we discussed earlier?
Of course. So yeah, the United States has, I mean, generally we've been shifting a little bit actually in our focus over the last few years. And for me, for most data security attorneys, this is very exciting to watch this shift. So, you know, in Europe, GDPR was passed, and then California, as many people know, was the first state to really pass a law that had significant similarities to GDPR like that. And just for some historical background, traditionally speaking, the US has always been very sectoral. So when we address privacy concerns, we usually do it with specific sectors. So healthcare has HIPAA, you have the FCRA and GLBA for, you know, credit data and banking data. But what GDPR did was say, we are protecting personal information generally for individuals who fall within, you know, our territorial scope, and some who fall outside of that, honestly. But in the US, we traditionally haven't had privacy laws that are that general. So when California passed the CCPA, it was a shift really to say, okay, you know, everyone who falls within the scope of this regulation has to protect personal information in these ways. And after California did that, many other states started introducing them, but no other states have passed a law that is quite as intense as California. Some other states have laws that take aspects of it, but we haven't seen another CCPA-esque law pass yet. But just in 2021, we've had at least 5 different states that have reintroduced very CCPA-esque legislation. And without getting into the nuances of CCPA, basically what it's doing is it's giving individuals, you and I, control over our data. And that makes a huge impact on businesses' operations, but also just the way that they are looking at this data. Because instead of just saying, this is my data that I can do what I want with, it's like, it's my data, but I have a responsibility to keep track of this data and to give consumers certain rights to this data because this data is about them. And that, again, is a pretty big shift. So the types of things that are in CCPA are, hey, you have a right to delete your information in certain circumstances. You have a right to ask about the categories of data that an organization has on you. And in some cases, you can even ask for the specific data that an organization has on you. And these are rights that businesses have to disclose to consumers. Businesses have to put in place a mechanism in which consumers can send these requests in. And so there's actually a big lift for businesses to kind of get up to speed. And all of this goes back to what we were saying at the very beginning of a lot of businesses are shifting to, you know what, this privacy regulation is happening so quickly. I want to be prepared for when it comes. I don't want to be scrambling once it's passed because, you know, if you're looking at the writing on the wall, states are passing these things. And just, sorry, one quick note, the CCPA also has special regulations when it comes to the sale of data. So going back to the marketing, this is where this ties in. If you are actually selling consumer data, you have higher requirements under the CCPA opposed to if you're not selling it. So it's just something important to keep in mind of what you're doing with this data.
Thank you. And I think that is a perfect segment to our final slide of the presentation. So next slide. Kristen mentioned one important point, and I think that is probably the one thing that, because I am in our nonprofit association practice group, so on principle, the clients I work with are not directly subject to the CCPA. That being said, there's so many new legislation being introduced at state and even federal level. So if you're not prepared, by the time something happens, you are probably going to be in scramble mode. So today, we hope this slide can give businesses and nonprofit organizations a little bit of a head start. If you haven't started doing some of them, this is your quick and dirty few items that you really should be thinking about and starting to prepare yourself to be in very good shape once the legislation takes effect that may impact your organization's operation. So among them, one of the requests I get a lot is to develop and implement appropriate policies. How do I come up with a good privacy policy, for example? And I think this one I'll have Kristen respond, is that many clients come to us and say, can you just swap my name for the policy? Don't you have a lot of templates that you work with? So, and this is when we say, well, every organization is different. We need to make sure you actually done data mapping, you know where your data is, this and that. But Kristen, do you have any suggestion when organization start to look at the type of policies that should be drafting, working with legal counsel, trying to prepare themselves from a privacy compliance perspective?
Oh, absolutely. As you just mentioned, even though I would love if a single privacy policy, if a single data security policy could apply to every organization, it's just not the way it works. And actually, the advice that I'm about to give in preparing you to look at what you need to do, kind of is evidence of this. So, the first thing, and we have this on the slide, is data mapping. And this goes back to what we were talking about with the GDPR principles. It's understanding your data, knowing what's out there, and knowing what you have to do with that data. So the first thing an attorney is going to ask you is, okay, well, what data do you have? Where is it at? Where is it being stored? Is it staying here in the US? Is it going overseas? Where is it going? What's it being used for? And the reason why we need to ask all of these questions is, again, like I said, the US is very sectoral, and certain data has more protections than other data. So something that might apply to one section of data might not apply to another section of data. And really, it's looking at the data and what's happening with the data that helps us determine what laws will apply. And then once we figure out what laws apply, we can then say, okay, what are the requirements here? And how can we best, put all of these requirements that this individual organization is required to follow into a policy that not only will meet all of these regulatory requirements, but is also simple and realistic for the organization. Because an organization that has 15 individuals working for it will have a very different policy than one who has 500 individuals working for it. So there's so much that goes into figuring out what to do with your policies and procedures, and it's highly customized, but that's, again, for the benefit of the individual organization.
Thank you. And I'm sure, Roz, you probably work with all of our firm's clients when there is a need for doing something at a very sophisticated level. So looking at this recommended action item list, what other thoughts do you have or suggestions for, especially for businesses and organizations that they haven't seriously considered or really drilled down to it? What are the things that you would recommend them do?
So if I were to kind of point out one aspect that has helped at least our clients be successful in adopting privacy programs at a level that they think is worthwhile and actually meaningful. Probably one of the more important things that we work with our clients is to help understand first what is driving their need for privacy protections. What is the business the business reasoning? It's often more than just we want to comply with the law, because that's always kind of been excuse me, the reason for a lot of things. And oftentimes our clients are looking to adopt a privacy program, not just to comply with the law, but also to prepare their organization for whatever is coming in the next few years in terms of privacy regulations. And a big part of that is protecting their reputation, for branding, for being able to go out in the marketplace and say your data is safe with us. We're kind of going above and beyond what the privacy laws require. So it's that aspect of, it's the extra benefit of the reputational benefit that is often the driver of adopting privacy programs. Whether that is supposed to be projected to individual users or our clients' partners in the US or overseas, it is ultimately a big driving factor. And when considering that, it helps to really kind of sync expectations, because the Europeans, for example, even though the GDPR is fairly new, we're going on 3 years now, the Europeans have been dealing with a law that's been substantially similar to the GDPR since the 1990s. US organizations, unless they're dealing with laws like HIPAA, or they're specifically regulated under the GLBA, or they're an insurance entity, a lot of this stuff is new. So kind of getting the expectations at a realistic level in terms of what's involved with respect to privacy protections, getting a true data mapping plan, developing all the privacy policies externally and internally, going through the vendor due diligence process and negotiating with each and every single vendor the ways that those vendors use the client's data is a process in itself. And so that's one of the things that I'm not saying it's overlooked, but again, going to the the theme that I seem to be having here, which is a lot of things are underestimated in the initial stages of adopting privacy and data security policies.
Thank you. So I think we do have a lot to, I'm sure the audience today would have a lot to think about, and hopefully we gave you a lot of food for thought. And for me, I would recommend taking a look at, again, the slide we have here in terms of the recommended action items. At the very, very baseline minimum, you probably want to inquire and review your cybersecurity insurance just to make sure that you are covered in the unfortunate event of a data breach. So that is actually security, not necessarily privacy, but I think that is one thing that is just as from a general business practice that should be probably on top of things that you can do quickly. So I hope you enjoy the presentation today. And again, if you have any questions about any of the action items, we have very good colleagues and reliable attorneys here to help you get there. So thank you very much. And thank you, Kristen and Roz.
Thank you, Dorothy.
Yeah, thank you, Dorothy and Kristen.